Please, I'm Charlotte Mitchell, Chair of the Utilities Commission, and with me this morning are Commissioners Brown Bland, Clodfelter, Duffley, Hughes, and McKissick. Commissioner Kimwright is recused from this proceeding. I now call for hearing docket numbers W-1333 sub-0 and W-1130 sub-11, which is in the matter of application by Currituck Water and Sewer LLC and Sandler Utilities at Mill Run LLC for authority to transfer the Sandler Utilities at Mill Run Wastewater System and Public Utility Franchise in Currituck County, North Carolina, and for the approval of rates. Before we proceed further, and as is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has a known conflict of interest with respect to matters coming before us in this docket. The record will reflect that no conflicts have been identified, so we will proceed. On May 20th, 2021, Currituck Water and Sewer LLC, to which I will refer as Currituck, and Sandler Utilities at Mill Run LLC, to which I will refer to as Sandler, filed with the Commission an application for transfer of public utility franchise and for approval of rates, seeking authority to transfer the wastewater utility system and public utility franchise serving the Eagle Creek Subdivision, the Eagle Creek Golf Club and Grill, and the Moyock Middle School in Currituck County, North Carolina, from Sandler to Currituck, and for the approval of rates. On November 18th, 2021, the Commission issued an order scheduling hearings, establishing discovery guidelines, and requiring customer public notice. The order scheduled a public witness hearing to be held remotely by way of WebEx on February 2nd and 2 sessions, one in the afternoon and one in the evening, as well as an expert witness hearing to begin on April 5th, 2022. On November 30th, 2021, Sandler filed a certificate of service stating that notice to customers was mailed or hand-delivered to all affected customers by the date specified in the scheduling order on November 24th, 2021. The intervention and participation of the public staff in this proceeding is recognized pursuant to North Carolina General Statute, Section 6215, Sub D, and Commission Rule R119, Sub E. No other parties have sought or been granted intervention in this proceeding. Between October 12th, 2021 and May 9th, 2022, various statements of consumer position were filed in this docket. The public witness hearing was held as scheduled on February 2nd in 2 sessions, at which 8 customers testified. On February 4th, 2024, Currituck filed the direct testimony of witness Myers. Also on February 4th, Sandler filed the direct testimony of witness Willis. On February 8th, 2022, the Commission issued an order requiring additional information from the parties, in which it requested that the parties provide responses to specific questions, as well as to requests for documents that were set forth in the order. On February 18th, 2022, Sandler filed its response to the Commission's February 8th order. On March 2nd, 2022, the public staff filed the direct testimony and exhibits of witnesses Tran, Franklin, Morgan, and the joint direct testimony of witnesses May and Tankard. On March 4th, 2022, both Sandler and Currituck filed their report on customer service and service quality complaints expressed during the public witness hearing. On March 11th, 2022, the public staff filed its verified response to the report of Sandler and its verified response to the report of Currituck. On March 22nd, 2022, Sandler filed its supplement to the report on customer comments from the public hearing. Also on March 22nd, Sandler filed the rebuttal testimony of witness Willis. On March 24th, 2022, the public staff filed a motion requesting that the Commission delay the expert witness hearing to and until Tuesday, April 12th, to allow the public staff, Currituck, and Sandler to complete discovery and adequately prepare for the expert witness hearing in this proceeding. On March 29th, Currituck filed a motion for an extension of the deadline by which it was to file rebuttal testimony. On March 30th, the Commission issued an order continuing the expert witness hearing to May 9th. On March 31st, 2022, Currituck filed the rebuttal testimony of witnesses Myers, Freed, Bissell, Bassnight, Beaumont, Honig, Lickfield, and Miller. On May 3rd, 2022, Sandler filed a notice of withdrawal of counsel Karen Kimwright and substitution of counsel David Drews. On May 4th, 2022, Sandler filed the corrected rebuttal testimony of witness Willis. On May 5th, 2022, Currituck filed a motion for another continuance of the expert witness hearing. On May 6th, 2022, the Commission issued an order continuing the hearing to June 8th. On June 3rd, the public staff filed a motion to continue the evidentiary hearing to June 9th, which motion was denied by the Commission by order issued on June 6th. On June 6th, the public staff filed the supplemental and settlement testimony of witness Franklin and the settlement testimony of witness Morgan. Also on June 6th, the public staff filed a joint motion to excuse Currituck witnesses Freed, Bissell, Bass Knight, Beaumont, Honig, Lickfield, and Miller, Sandler witness Willis, and public staff witnesses Morgan, Tran, May, and Tankard from appearing at the June 8th expert witness hearing. This motion was allowed by order of the commission issued on June 7th. On June 7th, Currituck filed the supplemental testimony of witness Myers. On June 7th, the public staff, Currituck, and Sandler filed a settlement agreement and stipulation. And also on June 7th, the testimony of Mike Myers was filed by Sandler. Actually, I have that already. Currituck filed the supplemental testimony of Mike Myers. All right. That brings us to today. I will call on counsel for the parties to announce their appearances, beginning with Sandler.
Good morning, Commissioners. My name is David Drews, appearing on behalf of Sandler Utilities at Mill Run.
Good morning, Mr. Drews. All right, Currituck.
Good morning, Chair Mitchell and members of the commission. My name is Brady Allen, and I'm with the Allen Law Office, LLPC. And beside me is my co-counsel, Britton Allen, and we are here today to represent the Currituck Water Services, LLC. Unfortunately, Mr. Finley was in an accident this weekend and is injured and was unable to appear today. He is still the counsel for Currituck Water Service, and we are just appearing in addition. Thank you.
All right, thank you, Mr. Allen. Good morning to the Allen brothers. All right, public staff.
Good morning. I'm Gina Holt with public staff here on behalf of the using and consuming public. And with me at council table is public staff attorney John Little.
Good morning, Ms. Holt, Mr. Little. All right, preliminary matters before we begin.
Yes, Chair Mitchell, I guess the first thing we would like to do is make sure that the application, the joint application of Currituck Water Service and Sandler Utilities to transfer the system is moved into the record.
All right, hearing no objection to that motion, it will be allowed.
Excellent. Next, my understanding is that the joint motion to excuse witnesses has already admitted most of the testimony into the record. We do have Mike Myers here today, and his testimony needs to be admitted to the record, so we'll call him to the stand when it's the appropriate time.
Okay,
That
and let's do this for purposes of clarity of the record. Let's go ahead and I'll have you move to admit the testimony for those witnesses, the testimony that's been pre-filed for those witnesses whose appearance has been excused.
Sure. We have the rebuttal testimony of Tracy Miller consisting of 29 pages, the rebuttal testimony of Mark Bissell consisting of 18 pages, the rebuttal testimony of William Freed consisting of 9 pages, the rebuttal testimony of Zach Bassnight consisting of 8 pages, the rebuttal testimony of Paul Beaumont consisting of 5 pages, the rebuttal testimony of Representative Robert Hanig consisting of 8 pages, and the rebuttal testimony of Gary Lickfield consisting of 10 pages.
And did you mention Tracy Miller?
Yes.
Okay.
Tracy Miller. Too.
Okay. All right, hearing no objection to that motion, it will be allowed. Testimony will be copied in the record as if delivered orally from the stand.
Thank you.
All right.
And if appropriate, we can move for the testimony of Brittany Willis to be admitted into the record as well.
All right, Mr. Drews. You've got the direct testimony, you've got the rebuttal testimony, and then you've got a correction to that rebuttal testimony. Is that correct?
That is correct.
Okay, so hearing no objection to your motion, the direct testimony, the rebuttal testimony, and the corrected rebuttal testimony will be copied into the record as if delivered orally from the stand. Okay.
Chair Mitchell, if this is the appropriate time, we also move the admission of the stipulation and settlement and exhibits into the record.
All right, hearing no objection to that motion, I'll allow it. And then Ms. Holt, when we get to your witnesses, we'll have you move testimony at that point in time. Okay. Currituck, call your witness.
Yes, Currituck Water and Sewer will call Mike Myers to the stand.
Yes. All right, right hand on the Bible, left hand on the Bible, raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take it away.
Morning, Mr. Myers. Could you please state your name and position for the record?
And my name is Mike Myers. I'm a Vice President, Secretary, and Treasurer for Currituck Water and Sewer.
Thank you. And did you cause to be filed on February 4th, 2022, direct testimony consisting of 39 pages?
I did.
And if I were to ask you those same questions today from the stand, would your answers be the same?
They would.
And to the best of your knowledge, are your answers to those questions in your direct testimony truthful and accurate?
They are.
Thank you. At this, yeah, and at this time, we'd move for the direct testimony to be admitted into the record.
Direct testimony of Currituck witness Myers filed on February 4th, consisting of, I have 39 pages.
Yes, 39 pages.
39 pages,
That's
okay.
what I
Shall be copied in the record as if delivered orally from the stand.
Thank you. And Mr. Myers, also on March 31st, 2022, you filed a rebuttal testimony. There was one set that was 23 pages and another set that was 33 pages. Is that correct?
That is correct.
And if I were to ask you those questions today from the stand, would your answers be the same?
They would.
And to the best of your knowledge, are those answers truthful and accurate?
They are.
And included in those rebuttal testimonies were exhibits A through N. Is that correct?
That's correct.
And I believe there are also maybe some attachments and appendices as well.
That's correct.
Okay, thank you. Chair Mitchell, I'd move that Mr. Myers' rebuttal testimony, including two sets, one I believe was 23 pages, the other was 33 pages, be admitted into the record, including the exhibits A through N and attachments and appendices.
All right, at this point, I'll allow the motion as to the testimony. The testimony shall be copied into the rebuttal testimony shall be copied into the record as if delivered orally from the stand. Exhibits to that testimony shall be marked for identification purposes as they were when they were pre-filed. I'll take a motion once your witness is, once we're done with your witness to move that in. All right.
Thank you. And also, Mr. Myers, on yesterday, on June 7th, you filed a supplemental testimony as well, consisting of 7 pages. Is that correct?
That is correct.
And if I were to ask you those questions today on the stand, would your answers be the same?
They would.
And to the best of your knowledge, are the answers to those questions accurate and truthful?
They are.
Thank you. Chair Mitchell, I would move that Mr. Myers' supplemental testimony consisting of 7 pages be admitted into the record.
All right, hearing no objection to your motion, I'll allow the supplemental testimony filed June 7th, consisting of 7 pages, to be copied into the record as if delivered orally from the stand.
Thank you. Mr. Myers, do you have a summary of your supplemental testimony that you're able to give today?
Sure. Supplemental testimony, in essence, it summarizes the joint settlement agreement between Currituck Water and Sewer and the public staff, as well as the settlement agreement between Currituck Water and Sewer and the consent order or the consent judgment that Sandler Utilities and DEQ have executed.
Thank you, Mr. Myers. The witness is available for questions.
All right, it's my understanding there is no cross-examination for the witness.
That's correct.
Okay, for the record, thank you. All right, commissioners, questions for the witness. Commissioner Kleinfelter, go ahead.
Mr. Myers, good morning. I have a couple of questions for you. We've got some terms that have been floating around in the case up to this point, and they continue to float. And that's probably okay. I'm not judging that, but there continue to be evidence of things yet to be done. We use the term sometimes modify, substantially modify, replace, and we use the words upgrade. All of those are future-oriented words. And so I want to ask you about one provision in the stipulation, just to be sure we're interpreting the stipulation correctly. In paragraph G, the Currituck is agreeing that it will not seek a general rate increase until such time as the vacuum system is replaced. And there's one of those words, replaced. I want to be sure we understand what's being committed to there. And let me ask you if, again, because sometimes the words used are modified, sometimes the words used are replaced, and sometimes the words used are upgraded. So would I be fair in interpreting that provision to mean that Currituck will not be requesting a general rate case until such time as what you refer to as the new system upgrade plan has been implemented?
That is correct, sir.
Whatever that is, whether that's a replacement, whether that's a modification of the existing system, whether that's some other upgrade, whether it's a wholesale replacement, whatever it is, until the new system upgrade plan is implemented, you won't seek a general rate increase.
That is correct. And I would
So,
just add,
so in paragraph G, the use of the word replaced is sort of a little loose wording, in other words.
yeah, I would say, our position has been from the beginning that the existing vacuum system out there has reached the end of its life and it needs to be replaced with one technology or another, whether that be low pressure, gravity, but that has been one of the, at least from the public's perspective, one of the more contentious issues is what will that replacement consist of?
Right.
And so we've been working with both the EQ and the community to kind of make sure that we try to address their needs with the replacement. But yeah, it's our intent to, or our commitment to replace that system.
I think in your settlement testimony, you use the word substantially modified or replaced, and that's a fairly broad, inclusive thing. It doesn't prejudge today exactly what that's going to consist of, right?
That's correct.
Good. Then I think we understand the stipulation the same way you do. So thank you for that. The next question I've got for you is just to be sure, again, we're all on the same page. The Currituck and the commission are on the same page. So Currituck understands that the only thing before the commission today is the approval of the transfer of ownership, correct?
That is correct.
And that today the commission, how it rules on the approval of the transfer of ownership will not at all involve any considerations of whether or not the company will or will not be in a future rate case entitled to recover any particular expenditures it may make on the system going forward.
That is absolutely correct.
Company
Yeah.
understands that.
Yep.
So whatever you agree with DWR, whatever you agree in the consent judgment, that's still got to be reviewed and evaluated by this commission for reasonableness and prudence and whether or not it's providing adequate, reliable service. And that won't be determined by this commission until a future general rate case. The company understands that.
We do, yeah. So
We're-
that's what we understand that. We're on the same page.
Commission's not signing off on any particular course of action today.
It's just transfer and nothing more.
We're with you. We're clear. Thank you very much for answering my questions.
All right, go ahead, Commissioner McKissick.
Thank you, Chair Mitchell. Just a few questions, and it relates to the consent order consent judgment, and particularly Exhibit B. And of course, that's the interim service and restoration plan. Now, underneath this particular exhibit, it states that there's going to be certain tasks that are taken care of on a daily basis, and it's outlined through, I guess, items A through G.
Mhm.
And then it moves down to what's being done on a weekly basis. And there are items A through E there. And then it goes to monthly system checks. And it's items A through C, and then some annual matters. Now, if you go back to the next section that follows this, it moves over to under item number 4. It talks about what's going to happen in case there's a sewer overflow or system failure. And it talks about what's going to take place to expeditiously restore and maintain service to homeowners in the event of those failures. And it specifically gets into what takes place within 4 hours. And under those conditions, it talks about remove and dispose of solid waste, apply lime to the affected areas, clean, sanitize the hard surfaces, and to the extent practical, vacuum any sewer overflows. Now, let me ask you this. Those are things that are always going to consistently take place within 4 hours, regardless of how many homes are impacted. Is that correct?
That is correct. Yes, sir.
Okay. So the language that is in the order earlier, we're dealing with materiality, which talks about what's going to take place when there's a material problem. That's separate, independent, and apart from that because it has to impact at least 4 homeowners. Is that correct?
Yeah, that's correct. So there's, on the vacuum system, there's 2 kind of primary assets out there. One is what's called the central vacuum station, and the other are the lines and the valves that are out in the community themselves. And that both have to work kind of in tandem. And so a lot of those individual tasks that you were citing there, those are related to specifically to that central vacuum station. And then the service response provisions that you were citing in there are related to the valves that are out in the community and if there's issues with the lines out in the community.
Okay, but it seems that the ones that deal with what I call sewer outfall problems, they take place and they're going to be responded to regardless of whether they're 4 households impacted.
That's correct.
All right. Because it wasn't clear to me in reading the section dealing with materiality. And materiality section, I guess, is on page 4. And it goes into what's going to take place if there's material things that occur.
Yeah, so the sewer overflows, that to clarify, that is whether it's 1 house or 4 houses, it's immaterial. If there's any sewer overflow, that'll be responded to immediately.
And I guess on page 5, there are provisions dealing with responding to citizens' complaints.
Yes, sir.
And it talks about responding in a timely way. And I guess in some instances here, they say if there's a material system failure, there's going to be a response in no later than 2 hours after receiving notice.
That's correct. Yes, sir.
And of course, it gets into more greater specificity about how certain responses will take place. And all of that language has been understood, agreed upon by the parties, and you feel that there's staffing in place that can accommodate all of the requirements of this consent order.
That is correct. Yes, sir.
All right. Thank you. I don't have any further questions.
All right, additional questions for the witness? All right, Mr. Myers, I have a few for you. Looking at the stipulation, section, I believe it's section 2, paragraph J indicates that y'all will file the Currituck agreement with Envirolink subsequent to the commission's approval of the transfer application. Why withhold until the commission approves? Why not go ahead and file that now?
That just popped up in this a settlement agreement within the last 2 or 3 days, and we just didn't feel that currently that agreement isn't in place, and so we needed time to get that agreement prepared and submit it over to the commission, and we didn't want to delay these proceedings.
Okay. Okay. So when will that agreement be in place? Do y'all have, when do you anticipate getting that agreement finalized?
Here over the next couple of weeks, we should be able to get that in.
Okay, so within the next couple of weeks, we'll expect it to be we can expect it to be filed in this docket.
Yes, ma'am.
Okay. All right. Responsibility for customer complaints. The stipulation involves reporting obligations, both some are quarterly, and I believe there may be monthly obligations as well. And you'd be obligated to report both to DEQ and DWR, and then I think also to the public staff under the stipulation. With these overlapping reporting requirements across state agencies, we're a bit concerned about the diffusion of responsibilities between agencies. Help us understand sort of what is your understanding of the respective roles of the public staff and the DEQ agencies involved?
I think first thing is, I think our understanding is there's quarterly reports, and that the same report that we would be filing with DEQ, we would be filing with public staff or the commission here.
Okay, so it's, just make sure I'm clear, as far as you're concerned, DEQ and the public staff will get the same information.
That is correct.
Okay.
And I'm sorry, can you repeat the last part of your question?
Yes, so our concern is the diffusion of responsibilities across the respective agencies involved here, as well as sort of confusion that might arise on the part of the customers of the system as to who's in charge here, to whom do we complain if there are problems, to whom do we look for, to hold the company accountable in the event of any future problems. And so I want to know your take on which agents, what the respective roles of the agencies are. You've testified, and I've heard your testimony today to be that you all will provide the same information, identical information to DEQ and the public staff.
That is correct.
And then in terms of outreach to customers, how will you address customer questions or concerns about our concern?
Yeah, so please make sure I
Okay.
answer your question correctly. But so DEQ, we see their role as regulating or oversight of the environmental and the operation of the collection system and the wastewater treatment facility. And that public staff or the commission's role is if there are customer concerns that Currituck Water and Sewer does not resolve satisfactory to the customer, they have the option to contact the commission and get their voices heard here. And additionally, if and when we do come in for a rate case, that the commission would then oversee rate regulations and service levels for Currituck Water and Sewer.
Okay. All right. The asset purchase agreement. So, attached to the application that was filed in this docket was, what is titled a revised and restated asset purchase agreement by and between Sandler Utilities at Mill Run LLC and Currituck Water and Sewer LLC. It's dated April 14th, 2021. There is also reference to an APA in the stipulation in the settlement agreement that the companies and the public staff have entered into. Is this April 14th, 2021, sorry. Is this April 14th, 2021 asset purchase agreement still the document that controls, or the contract that controls, the rights and obligations between Sandler and Currituck?
It is.
And it hasn't been amended or revised, or is
It
that?
has not.
Okay,
No.
it has not. Okay. Okay. We have some questions about timing of the transaction here. In my quick review of the APA, it does not appear that that as a precedent or a precondition to closing, that all governmental approvals have to be secured. Is that, am I reading the APA correctly?
That is correct. The typical process with DEQ is that the closing has to happen first before they will accept the change of the owner on the permit. So after the commission order comes out and then we can move to closing, then we'll be able to file to DEQ to get the permit's name, it's called name and ownership, changed over to Currituck Water and Sewer.
Okay, so help me just make sure I've got this right. Assuming the commission approves this transfer application, then you all would close, and then you would move to DEQ to have the permit transferred to Currituck, from Sandler to Currituck.
That is correct. And one other thing that probably is important for the commission to hear is that the consent judgment that Currituck Water and Sewer has negotiated with DEQ would not become effective until DEQ issued that permit in Currituck Water and Sewer's name. They intend to file it with the courts ahead of time, but it would not become effective until the DEQ issues the permit.
Okay, well, as I understand it, it wouldn't become effective until a judge executes the order. Is that
correct.
correct? So the judge, I'm not sure if we can control the timing of when a judge executes the order, but what I'm hearing you say is that that won't happen until the permit is transferred to Currituck.
Water and Sewer, yes, ma'am.
Okay. Okay. Whose responsibility is it to, let me back up. Has that second amended consent judgment been filed already with the Currituck County Court?
It has not, to my knowledge.
Okay. Do you know when it will be filed?
We do not. I think my understanding is the Attorney General's office and Sandler Utilities will take the lead on getting that filed with the courts.
Okay. And when, do you know when they plan to do that?
Timing wise, we've been told that that can happen prior to the permit application going in and prior to Currituck Water and Sewer and Sandler closing. They can file it with the courts. I think any time now. It's but the timing on when the judge will rule on that, we don't know. But assuming he did adopt it, that it wouldn't go into effect until the actual permit came out.
Okay. I'd like to ask counsel for Currituck to provide notice to the commission once the second amended consent judgment has been filed with Currituck County.
Understood, Chair Mitchell.
Okay, thank you. All right. Mr. Myers, what is your experience or what do you have any thoughts on how long it will take DEQ to approve the transfer of that permit?
Typically, it's a procedural issue with them, and they can issue it fairly quickly. I would say under 30 days, though there have been occasions when it's taken them longer to do that. I think there's a priority on the divisions from the division's perspective to want to process this as quickly as they can.
And will the transfer be handled by a regional office or a central office?
Central office.
Okay.
Commissioner Mitchell, if I can add something to that.
Please do.
There are two permits out here for that Sandler has on this. One is related to the treatment plant. The other is related to the collection system. The treatment plant permit has been issued. It's not expired. It's valid out there in Sandler Utilities' name. The collection system permit is in for a permit renewal. So the name and ownership change will likely be combined with the collection system permit renewal application that's already been filed.
Okay, make sure we got that right. So it's the collection system permit that's in for renewal, or it's the non-discharge that's in for renewal?
No, it's the collection system permit that's
Okay.
in for renewal.
And just following up with you there, is it just going to test your memory here, but because you're sort of addressing one of the questions we had for you, but is the collection system permit WQCS 00290? Does that seem right?
The WQCS certainly is the collection,
Okay.
indicates the collection system permit. Now
Okay.
I'd have to go back to you're asking too much of my memory to remember.
Okay, and then so the WQ permit,
That's
that
for
would
the
that would be
treatment.
that would be the discharge permit,
Or the non-discharge permit.
non-discharge, to be clear, it's the non-discharge permit. Okay.
That's correct.
So both the collection system permit and the non-discharge permit will be transferred to Currituck. The transfer of the collection system permit will take place in conjunction with renewal of that permit. That is how I understand your testimony. Do I understand your testimony correctly?
You do. That's our understanding.
Okay, thank you. What's the timing of the issue? What is your understanding of the timing of the issuance of the collection system permit?
We did get notice, I think about 30 days ago, that they have assigned that permit renewal to somebody over at the division.
Okay.
So it is being actively worked on now.
Is it also being handled by central office?
It is.
Okay. Okay. All right, Mr. Myers, assuming the commission issues an order accepting the stipulation and approving the application for transfer. When will Currituck file the agreed upon bond?
We're working with the bonding agency right now. I would expect that to be with 1st of July at the latest.
Okay. All right, the stipulation, you don't have it, okay. Stipulation, page 6. We're looking at, again, section 2, page 6, paragraph B. References all other regulatory approvals for operation of the wastewater system being attained. Which other regulatory approvals are we talking about?
The only regulatory approvals, aside from the transfer proceedings here, would be the 2 DEQ permits that we've been talking about from DEQ. Those are the only permits we need to operate.
Okay, so okay, all right, got it. All right, Commissioner Clodfelter went over that information for you. Can you explain, for the commission's benefit, the changes to the corporate officers for Currituck since the filing of this application?
I think there was initially when we went in there, this was all under Longleaf Utilities. Longleaf Utilities then restructured the organization, and we have a equity partner, Clear Current, that is providing the equity needed for what we need, the project that we need to do here.
So, Ken Raber still involved?
Yes.
And in what capacity?
He's a board member, president of Currituck Water and Sewer, and a board member.
So he's president of
Currituck Water.
the operating company?
He is.
Okay. And then what about David Strum?
David Strum is director of operations and also an officer and vice president of Currituck Water and Sewer.
Okay. And what are the plans for your participation in the operating company?
I'll be one of the board members in Currituck Water and Sewer,
And
and
will you-
vice president, secretary, and treasurer.
Okay. Okay. For purposes of the record, will you confirm the exact date that Envirolink entered into a contract with Sandler for the operation of the Eagle Creek wastewater system?
So that was actually how we got involved with Eagle Creek, was actually through an acquisition of a company on the Outer Banks called Envirotech.
Mm-hmm.
That transaction was closed in February of 2020 with a 6-month transition period. So the previous Envirotech employees and owner continued to operate Eagle Creek until August of 2020, and September of 2020. And then in September of 2020, the Envirolink staff took over operations of the Eagle Creek wastewater system.
So September 2020, Envirolink personnel took over operations.
That's correct.
Okay. Was there any sort of documentation between Envirotech and Envirolink that sets forth the terms and conditions of that, what you call the 6-month transition period?
Yeah, I believe it was in the agreement between Envirolink and Envirotech, the purchase agreement, that stipulated that there would be a transition period.
Okay.
I don't know that it stipulated 6 months. It kind of was vague in terms of it stipulated a transition period.
But your testimony today is that until September, until through, at least through August, the Envirotech personnel continued to operate and maintain the system. And then in September, Envirolink personnel,
The exact date is September 7th.
September 7th, okay. And who from Envirolink stepped in to take over the operations?
So the project manager is a gentleman named Tracy Miller.
Okay. Okay. All right, I'm going to ask as a late filed exhibit, the agreement between Envirotech and Envirolink.
Okay, sounds good.
Um, all right, Mr. Miller's rebuttal testimony explains that competitor technology has replaced the air vac systems in other locations. What is meant by competitor technology?
So there's, I think, two other companies as we've done our research into vacuum systems. There's two other companies, Flowvac and Quavac. Flowvac having operations in the U.S. Quavac does not have operations in the United States. But globally, both of those competitors of AirVac have gone in and done retrofits on what were formerly AirVac systems.
Okay, so that competitor technology specifically meant vacuum system technology.
That is correct.
Okay. Um, were the residents of Eagle Creek informed about the precautions or the contingencies that Currituck's planned for the construction of the gravity sewer system?
Yeah, so I think all totaled, there's been in the range of about 10 town hall style meetings that Currituck Water and Sewer has conducted with the residents out there to kind of keep them abreast of both the process through these proceedings and our evaluation of the different technologies and the construction techniques to address a number of their concerns. So yeah, that information has been conveyed to the residents.
And how did the residents receive that information? Specifically, how do the residents receive the information relating to the precautions or the contingencies that would be observed if the
There's
system were to be
both
replaced?
verbally through the town hall meetings, and then we have put out kind of informational brochures and presentations to the community.
Okay, specifically, my question, I wasn't clear. My question is, how do they react to the
Oh, yeah.
information?
Yeah, I think there's still, understandably, there's a lot of frustration by the community out there because, this system has had service issues as far back as we could identify back to 2020, 2002. There have been service issues out here on this system, so there's a fairly high level of frustration with the community. I think their concerns is during the construction phase, disruptions to the community during construction, tearing up yards. And so we've talked to them about directional drilling techniques, construction methods that can minimize. But I think we've been very forthright with them that there is going to be a disruption during the construction phase of this project. And they hear the 6 to 9 month construction window. And I think that concerns them a lot.
Okay. Mr. Freed, I'm going to ask you about your co-witness testimony since you can follow up there, sure. You may.
There's a lot of talk of dealing with the quote community. Could you just tell us a little bit about the sort of governance structure that you're facing there versus other places that you might have worked? Is it a solid homeowners association that you're going through? Is there a water task force that has been created? Is it just a series of vocal individuals that are kind of dealing independently with you?
I think it's all of the above. So they do have an HOA that we have worked from the beginning. We've worked through. Initially, we were working directly with the board of the HOA, and then they appointed one of their residents as kind of the liaison. She's an engineer in the water industry, working for a consulting engineer. So they appointed her to kind of work with us as we work through this. But then there are citizens out there who, outside of the HOA, who don't feel like the HOA is adequately representing them, and so they've voiced their opinion separately.
All right, Mr. Myers, Mr. Freed's testimony, specifically as the rebuttal testimony filed for Mr. Freed, mentions that Sandler was made aware of the problems with the wastewater treatment facility through several reports over the years. I mean, he just sort of makes generic reference to reports. What are these reports? What's the source of these reports? Were the reports made by Envirotech, or were they made by some other third-party engineer or a regulator?
Yeah, we're unaware, other than inspection reports from DEQ, we have not been able to find any other reports filed by Envirotech or third-party engineers or anything like that. One of the records from Envirotech we've not been able to find a lot of records in terms of the operation of the Eagle Creek system. Mr. Freed did not if he has them, he did not turn them over to us.
Okay, so then do I understand your testimony to be that the only source of reports that that Currituck was able to identify would have been inspection reports from DEQ or
That
the
is correct.
DEQ agency involved?
That is correct.
Okay. Mr. Myers, in your testimony, there's a presentation that was, there was attached a presentation that was made at one of these town hall meetings in January of this year. And in that presentation, there's reference to a low pressure sewer alternative. It's the low pressure sewer alternative is identified as being both economically and technically infeasible. Help us understand why that is.
Yeah, so, and maybe there's a little bit of an update on that analysis so the initial quotes that we have got in from the contractors for low pressure actually were higher than installation of gravity for the community. We have since that presentation gone back out to the contractors and asked them to kind of give us some updated pricing. Those numbers have come down to where they are competitive with gravity at this point in time. That's an update since that presentation went out, but at that point in time, gravity was from a financial standpoint, cost standpoint, the more attractive alternative.
Okay. Can you provide an update to us on the status of the construction of the collection system serving the Faust and the Flora subdivisions?
So the pump station force main, that work is complete and been commissioned and certified by the engineer. Startup on that pump station there's no flow coming to it, but startup has been done. Phase 1 of the collection system on the development side is in and installed and certified. They are currently, the design for phases 2 through 5 on the collection system for Faust are ready to be submitted to DEQ. We have DEQ coming out for an inspection on Friday of this week that is tied to our submittal of that permit application with the division.
Okay. And what type of collection system was installed?
Gravity.
Gravity. Okay. All right. LM Sandler and Sons. How is LM Sandler and Sons connected to Sandler Utilities, if at all?
I believe they're affiliated organizations, but if I can look to Mr. Drews, he may be able to confirm my understanding.
Okay, tell me, hang on. Tell me what you know about Sandler and I mean, is the extent of your testimony that you understand them to be affiliated, but you don't?
I don't,
Do you
yeah,
know
I can't
anything else
confirm
about
the
them?
ownership structure or anything like that within the organization.
Okay. Mr. Drews, I'll ask for a late filed exhibit explaining the relationship between LM Sandler and Sons and the Sandler Utilities at Mill Run LLC. All right. Last question for you, Mr. Myers. Is there a difference between the service lives of rebuilt valves and controllers as opposed to brand new valves and controllers?
There is, but I would say that one of the unique features of these controllers that are inside the pits that doesn't tie to kind of the life of that unit is that there's a membrane inside that controller that if it gets wet, renders that controller non-functional. So even though that valve may have, several more years of life on it, it will, if it gets wet during the course of its operation, that valve or that controller will need to be rebuilt.
Okay. The lawyer up here doesn't understand how you could have a component in a wastewater treatment system that would fail upon getting wet, but
That's been a very valid and good question, and one that I know we've asked
well, I just
several times.
certainly someone smarter than I am developed it. So anyway, all right. Let me pause here and see if we've got questions from. All right, no additional questions. I will check in with council to see if there are questions on the commission's questions. Ms. Holt.
No questions.
All right, Mr. Drews, go ahead.
Mr. Myers, I'd like to ask you a little bit about the transition from Envirotech to Envirolink. And my understanding was that Envirolink, which is a company you're part of, is that correct?
That is correct.
And acquired Envirotech in February 21, is that?
Yeah, late February 21, or I'm sorry, 2020.
2020, I'm sorry, that's right. And Mr. Freed was the principal operator of Envirotech?
Well, he was yes, sir.
Okay. And is it fair to say that it is not easy to find qualified operators of vacuum systems in North Carolina?
I think not just North Carolina, but I think nationally, because of when you look at the universe of collection systems, vacuum systems comprise a very small percentage of that technology out there. And it does take a different skill set from some of the other technologies that are out there.
And is that one of the reasons why Envirolink wanted that transition period?
I would say at that point in time, we didn't necessarily, while we knew Eagle Creek had a vacuum system and it was certainly part of the thought process, it was more of understanding the operations of, in addition to Eagle Creek, a number of their other systems that they were operating and allowing kind of a smooth transition from Envirotech to Envirolink.
At that time in February 2020, was Envirolink deeply experienced in operating vacuum systems?
We were not.
Okay. And did that period of, let me back up a second, did Envirolink employees to some degree shadow Envirotech in that transition period?
They did.
And was part of that process to learn more about how to operate the vacuum system?
It was, and it also gave us the opportunity to send some of our managers to vacuum training by the manufacturers themselves.
And after some of the significant malfunctions in the fall of 2020, did Flowvac or other companies brought in by Sandler provide additional training to Envirolink?
Yeah, over the, during that period and since that period, there's been several training events provided by Flowvac in particular to our operators and even some of the Sandler staff.
And given the experience and training that Envirolink staff have had since 2020, do you view Envirolink as experienced and qualified to operate the vacuum system, setting aside that some upgrades are needed and it's not necessarily the best technology? Is Envirolink's competency at a level now where you feel like you can do a good job for the customers?
Certainly that's true. I would also add to that there's been some some things that we have done and that Sandler have done that I think have, while the system is still vulnerable right now, allow us to focus more on a long-term solution for the community. And specifically, I'm speaking of, there has been a monitoring system that has been installed on the system. Little bit of background: if there is an issue with a service in the community, and I think this is valuable for the commission here. If there's an issue with a service in the community, that all up until when the monitoring system got put in, all our guys were able to do was identify there is a problem in the community somewhere. They weren't able to identify where the problem was. So they would have to go home to search each home to find out where that issue was located. And if you did not locate it and find it within a period of minutes, the system would lose vacuum and the entire community would be without vacuum. So the installation of the monitoring system that has been done allows us to, one, be alerted there is a problem sooner, to allow our guys, and we have guys that are out there now 24 hours a day, 7 days a week, allow our guys to identify there is an issue sooner, but they're also able to identify where the problem is at. And so those two things, with the 24-hour coverage and the monitoring system being installed, I think have been the most effective in terms of service and being able to sustain service out there of anything that's been done to date.
Okay, and after you acquired Envirotech, did Envirolink enter into a written agreement to become the contract operator for Sandler Utilities with a 5-year term? If you're familiar, if you're not, that's okay.
Yeah, I want to say I think so, but I'm not 100%.
Okay, that's all my questions. Thank you.
No
Questions?
questions.
Okay. All right. At this time, I believe, Mr. Myers, your morning is concluded.
Chair Mitchell, if there is such a 5-year operating agreement and it's not already in the record, can we have it supplied as a late exhibit? It may already be in the record. I just don't remember.
We will supply that.
Thank you.
All right. With that, Mr. Myers, you may step down and I'll take a motion.
Yes, Chair Mitchell, I would move that the exhibits of Michael Myers' testimony be admitted to the record, including from the rebuttal exhibits A through N, and along with the attachments and appendices as identified in the testimony.
All right. Hearing no objection to that motion, it'll be allowed. I also want to remind you all, let's see, Mr. Drews, I will take a motion from you regarding the report filed by Sandler on customer comments.
We would ask that be admitted into the record as evidence.
All right. Hearing no objection, Sandler's, the report filed by Sandler on March 4th will be admitted into evidence. Currituck, similar from you.
Yes, we would ask that it be moved into evidence.
All right, the report filed by Currituck on March 4th, 2022 will be received into evidence. Hearing no objection to that motion. Sandler Utilities filed a supplemental report on customer comments, March 22nd.
We would also ask that be admitted into the record as evidence.
All right, hearing no objection, we will allow that motion. Sandler filed also a response to the commission's February 8th order on February 18th.
Yes, really, everything we filed, we would ask to be admitted into evidence. I don't know if
All
that's
right, all
too
right.
much a shortcut for the
It is,
commission
that
or
is
not.
too much of a shortcut, Mr.
Okay.
Drews. There's been a lot filed in this docket. All right, so, Mr. Drews, I understand your motion to be that Sandler's response to the commission's February 8th order, which was filed by Sandler on February 18th, which included as an attachment the consent judgment and amended consent judgment, be admitted into the evidence, and that motion will be allowed.
Thank you.
All right. All right, with that, anything further from the applicants?
No, that's all, Chair Mitchell.
Okay.
So,
All right. Public staff, you are up.
Public staff would call as a panel witnesses Michael Franklin and Iris Morgan.
All right. All right. Good morning, Ms. Morgan, Mr. Franklin. Would you all please sit on down? And I'll get you sworn in. All right, place left hand on the Bible, raise right hand. Swear testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you very much. All right, Ms. Holt, you may proceed. Y'all may proceed.
Mr. Franklin, would you please state your name, your position at the public staff, and your address, please?
Yeah, my name is D. Michael Franklin. I'm a public utilities engineer in the water, sewer, and telephone division. My work address is 430 North Salisbury Street, Raleigh, North Carolina.
And on March 2nd of this year, did you pre-file direct testimony consisting of 36 pages, an appendix, and 5 exhibits?
Yes, I did.
And do you have any changes or corrections to the pre-filed direct testimony?
I actually do. On page 27, line 21, it should read page 2, line 22, and page 3, lines 1 through 6, versus page 2, line 22, and pages 1 through 6.
And did you say that was page 27?
That's correct.
Okay. Do you have any other corrections?
I do not.
And on June 6th of this year, did you pre-file supplemental and settlement testimony consisting of 8 pages?
Yes.
And do you have any changes or corrections to the supplemental settlement testimony?
I do not.
And if I were to ask you the same questions in your pre-filed direct testimony and your pre-filed settlement and supplemental testimony, would your answers be the same?
Yes, I would.
And do you have a summary of your testimony?
Yes, I do.
Would you read that,
Sure.
please?
The purpose of my direct testimony filed on March 2nd, 2022 is to provide the commission with the results of my investigation into specific areas of the application filed on May 19th, 2021 by Currituck Water and Sewer LLC, also known as Currituck, in docket number W-1333 sub-0, and Sandler Utilities at Mill Run LLC, also known as Sandler, in docket number W-1130 sub-11. For transfer of public utility franchise and for approval of rates and referred to as the joint application, and whether the transfer is in the best interest of the using and consuming public. In addition, my supplemental and settlement testimony filed on June 6, 2022 provides an update to plant in service and support for the settlement agreement and stipulation filed on June 6, 2022 between Currituck, Sandler, and the public staff. Currituck proposes charging the current commission-approved rates and connection charges for Sandler as specified in docket numbers W-1130 sub-9 and M-100 sub-138. However, Currituck proposes charging different reconnection charges than the current commission-approved reconnection charges for Sandler. Although the reconnection charges differ, the proposed rates and fees are just and reasonable. In the joint application, in responses to public staff data requests, Sandler has provided plan additions from 2016, the year following its last rate case, through May 2022. I recommend a total of $515,820 for plan additions as reasonable and appropriate for inclusion in plan in service. As shown in Morgan's Supplemental Exhibit 1 and reflected in the stipulation, the net plan in service amount is $424,779, which is appropriate for inclusion in rate base as it is less than the purchase price of $613,623. Consistent with North Carolina General Statute 62-110.3 and the stipulation conditions, the public staff believes a $650,000 bond is appropriate to ensure the provision of adequate and sufficient service to Eagle Creek Subdivision, Mill Creek Golf Club, and Moyock Middle School. Considering the conditions of the second amended consent judgment, the additional conditions in the stipulation to which Currituck is subject, the bond amount, and the testimony of public staff witness Bob Tran establishing the financial viability of Currituck, the public staff believes that the customers of the Eagle Creek Subdivision will be adequately protected and the transfer is in the best interest of the customers. The public staff therefore recommends approval of the joint application that will transfer the Eagle Creek wastewater utility system from Sandler to Currituck at the existing approved rates. As provided in the stipulation, approval of the transfer is still conditioned upon the second amended consent judgment being entered in the Superior Court of Currituck County and upon all other regulatory approvals for operation of the wastewater system being obtained. This concludes my testimony summary.
Chair Mitchell, I move that Mr. Franklin's direct testimony and supplemental and settlement testimony be copied into the record in this proceeding as if given orally from the stand, and that the appendix and exhibits attached to his direct testimony be identified as marked when filed.
Hearing no objection to that motion will be allowed.
Ms. Morgan, would you give us your name and address and your position at the public staff, please?
Yes, my name is Iris Morgan. My position, I'm a financial analyst at the Public Staff Accounting Division at 430 North Salisbury Street, Raleigh, North Carolina.
Ms. Morgan, on March 2nd of this year, did you pre-file direct testimony consisting of 7 exhibits and 1 exhibit consisting of 5 pages?
Yes.
Do you have any changes or corrections to that testimony?
No.
And then on June 6th of this year, did you file supplemental testimony consisting of 5 pages and exhibits of 1 exhibit consisting of ten pages?
Yes.
Do you have any changes or correction to that supplemental and settlement testimony?
No.
And if I were to ask you those same questions in your pre-filed direct testimony and your pre-filed supplemental and settlement testimony today, would your interest be the same?
Yes.
Did you prepare a summary of your testimony?
I did.
Will you please read that?
Yes. Currituck Water and Sewer LLC filed rebuttal testimony on March 22nd, 2022. My supplemental testimony revises my direct testimony and exhibits to reflect updated information the company provided to the public staff subsequent to the filing of the public staff direct testimony and exhibits. In addition, my supplemental testimony presents updates recommended by public staff witness Franklin as a result of the public staff review of additional information provided by the company. Based on the result of the public staff's investigation, net plant in service at June 30th of 2022 is $424,779, consisting of plant in service of $2,722,022, reduced by accumulated depreciation of $359,644, and contributions in aid of construction of $1,937,599. Additionally, I calculated the purchase price of $613,623, consisting of $250,000 from the asset purchase agreement and $413,590 of additional plant items, less $49,967 of accumulated depreciation as shown on Schedule 2 of Morgan Exhibit 1. This concludes the summary of my supplemental testimony.
Chair Mitchell, I move that Ms. Morgan's pre-filed direct testimony and pre-filed supplemental and settlement testimony be copied into the record in this proceeding as if given orally from the stand, and that the exhibits and attached to the testimony be identified as marked when filed.
All right, hearing no objection to that motion, it'll be allowed.
Yeah, one, before I offer up the panel for cross-examination, there is one thing I would like to do. In commission questions for Mr. Myers, there was referenced a verified response but from the public hearing of Currituck. The public staff filed a response to that filing on March 14th, and it's titled verified on March. We filed two responses, excuse me. On March 11th, 2022, the public staff filed the verified response of the public staff on customer comments from public hearings by Currituck Water and Sewer LLC. And then on March 14th, the public staff filed the verified response of the public staff on customer comments from public hearings by Sandler Utilities at Mill Run. Like those marked as exhibits and pending any objections and questions admitted into the record.
All right, Mr. Little, what I'm going to do is I'll call for a motion from you for all evidence public staff wants to move in subsequent to these two witnesses. And so I'll entertain this motion at that time, just so we keep the record clear.
That's fine, thank you.
And just to be sure, you referenced your public staff's response to Currituck's report, which was filed on March 11th. Is that right?
That's correct.
And then public staff's response to Sandler's report, which was filed on March 14th.
That's correct.
Okay. All right. So please do just I'll entertain that motion subsequent to disposition of these witnesses.
Thank you. And the panel is available for cross.
All right. Let me check in with commissioners, see if we've got questions. I'm assuming no cross for these witnesses. Okay. Go ahead. Go ahead.
Mr. Franklin, I've got a question for you that's really more general in nature. It's certainly pertinent to this case because of its history and it's the way it's probably going to go forward from this point. But it also would be applicable to other cases. It just happens to be that this is the first chance I get to talk to you about it here. So talk to me a little bit about how public staff and DWR sort of handle the somewhat overlapping or somewhat concurrent responsibilities when you've got customer issues. How does that work with DWR? Just give me a general education about it. Yeah.
Well, normally we interface with on wastewater systems, DWR, to get for rate cases especially, we get notices of violation and that type of information from them. And typically, there's an engineer assigned to each wastewater system from DWR that we interface with. With consumer complaints, oftentimes there's confusion on the customer's side whether they should contact DEQ or contact us. And quite honestly, sometimes there's confusion on our side whether it's a public staff issue or a DEQ. But as Mr. Myers explained, if it's a regulatory issue, we always refer them back to DEQ. If it's a service issue or a customer service issue or something involving rates or those type of concerns, and we refer them to the Consumer Services Division in the public staff.
I may be the only one here who doesn't know, but the only way I find out things I don't know is to ask questions. So excuse me if I'm the only one that doesn't know it. Or have there ever been any thought given to trying to sort of formalize protocols between DWR and the public staff about how you respond to customer complaints? Are there any formalized protocols?
Not that I'm aware of, no, sir.
Has that ever been something that's been discussed with DWR about who's going to take the lead on what kinds of things and who's got the first call and who's got the second call and how that works?
Not that I.
Not that you know.
Not that I know of. No.
Okay. Just curious again, because it comes up in this case, but it's also come up in other cases and
Sure.
it will in the future. So I was just
Sure.
curious. Thank you for helping me out today.
Sure.
Appreciate it.
Commissioner Brownbland.
So following up on what you were just discussing with Commissioner Kleinfelter, is there a routine and regular practice of both of the agencies, that is public staff and DEQ, letting the other know that they've received a complaint?
I mean, the experience I have had is, yes, because what will happen, DEQ will, if it's something that I'm involved with, they will call me and say that they've received a complaint and they think it's more on the public staff's side of the house. And likewise, if I receive something, then I reach out to the DEQ, typically to the regional office who's in charge, and refer that to them.
Is that happening and occurring because the one that receives it thinks that it belongs to the other? Or my initial question is there just an informational notification that we're having issues with this system or these customers? Is there, do you see the need to have any such, just a running list of knowing what's happening with the systems from the DEQ side?
I think for some of the systems that have been problematic, we've had more of a sharing of information and identification of ongoing issues or new issues. But I think on some of these others that aren't, we don't hear too much about, and they seem to be operating fairly reasonably or adequately without, with an occasional violation, we don't get that type of sharing of information. But the ones that are more problematic, I do see more sharing of the issues and getting each other involved.
So would it be fair to take from what you say that you don't see the need that all the complaints that might come into DEQ just be on your radar somewhere, or just receive some routine list of this month we had complaints from these systems, just for your information?
I think communication is very important, and the more we communicate with each other, the better off we both are. That's my personal position on that.
So maybe something to think about. So with respect to this transfer docket that's in front of us in these systems, I guess there's a split jurisdiction between the two about certain issues, but
Right.
Are the customers in any way told so that they can process that for themselves, who to call? Should they start out?
For this particular one, they started going directly to David May, who was the regional DWR supervisor in the Washington regional office, about complaints. But again, those were primarily the sanitary system overflows that they were experiencing. And we initially, when they first had the large outage in September of 2020, we received calls that were sent to consumer services. But after that, most of the identification of issues was handled through David May and his group. But they always included me on the complaints and any email that they received or that they sent.
And in your testimony here, you've stated that the public staff intends to closely monitor any complaint, service, and/or compliance issues reported due to inconsistent performance from Envirolink in the past. What does that mean to you? How you follow it closely? Do you plan to follow? Does that necessitate you having a higher level of communication with DEQ?
I think because of this particular system, there will continue to be the interfaces that we currently have and the communications that we currently have. And I'm also listed on the HOA's website for the Eagle Creek as a contact. And so I get communications directly from homeowners through that information. And also, again, David May and I communicate back and forth with information that we receive, and I expect that to continue.
All right, thank you, Mr. Frank.
Commissioner McKissick?
Sure, and this is along the same line of questions that Commissioners Clotfelder and Brown Bland have been asking. I mean, and perhaps you can help me with this, because I know in the consent judgment, you know, this page 5, section 4, I mean, it specifically addresses responding to citizens' complaint. And it provides a great deal of specificity. You know, under subsection A, it talks about when a resident complains about a material failure, and again, material is affecting at least 4 homes, that within 2 hours of receiving a notice, it's going to respond to the citizen. And then it says under section B, in terms of initiating response to citizens' complaints for equipment failures, systems failures, sewer outfall problems, so they're going to do that within 3 hours of receiving the complaint. And then it gets down to subsection C, it says in terms of providing sanitation services, that's going to be provided within 4 hours of confirmation of the discharge. And it gets down to D, and it talks about, you know, continuously performing sanitation surveys. And then going down to E, notifying residents of full system restoration. So once it's done within 2 hours. And then it's going to be a report prepared that the Currituck's going to give to DWR, and it's going to be pretty precise. You know, it's going to maintain an accurate log of the resident's complaint, actions that were taken to those complaints, identify the complainant, summary of the substance of the complaint, when the complaint was received, description of the action taken in response to the complaint, including my limited correction action plans, when the response was initiated, when the complaint was resolved. Now, all of that's going to DWR. At what point do they have a feedback loop that perhaps shares that information
I
with
believe
the
in the,
commission?
I'm
Because
sorry.
go ahead, yeah.
I believe in the stipulation agreement or in the settlement agreement, there's also requirements for them to file similar information with the commission.
I think that's quarterly, though. Yeah, or is that more frequent? And perhaps you're correct about that. I know that it seems like there were some quarterly reports coming in.
Either way, again, because of our concerns that have happened, you know, with this system over the last several years, we will interface directly with DWR about the complaints they receive. And we're also going to, I think we need to educate the homeowners also about consumer services, because we want to track complaints as well so that we can monitor them more closely internally. And by having them filed with, or have them register a complaint with consumer services, that also gives customers some additional options about getting their complaint addressed. So I've already talked to the vice president of the HOA that that's our plan, and that we're going to ask consumers to also file a complaint with consumer services over service issues.
Well, I'm glad to hear that, and I hope it works out that way. But as I remember from reviewing the case file from when the current owner was last before the commission, there was language in the order about monitoring and providing information and follow-up. As I recall, the follow-up on the public staff side was not as conscientious.
That's true.
So I hope we will see a more vigorous effort to remain engaged
Yes, sir.
as this moves forward.
That's certainly our intent.
Thank you.
All right. Thank Thank you all for your testimony so far and your participation in this proceeding. I have a few more questions for you. First, Mr. Franklin or Ms. Morgan, will y'all just confirm for me that the purchase price is now $613,623?
That is correct.
Okay, and that's clearly set forth in the settlement agreement. Just wanted to make sure I was reading it. All right, I took a look again at the asset purchase agreement. And there's a section in the agreement, specifically it's in Article 4. And I know y'all probably don't have this in front of you, so you're just gonna have to accept this subject to check. It's Article 4, Section 4.2, which is titled Purchase Price. And then subsection C deals with rate-based treatment of purchase price. And this contract provision provides that in the event the commission fails to establish the rate base or the buyer is not satisfied with the amount of the rate base the commission establishes, buyer has rights to walk away from the agreement. I'm paraphrasing, but that's the way I understand that provision. I assume, given that the parties have settled here, that irrespective of this term in the APA, you all are not aware of any interest on the part of the buyer to walk away from the agreement?
That's correct. We're not aware.
Okay. Okay. Was this contract provision discussed at all during the course of the settlement, to your knowledge?
We just requested and required that Sandler make sure that they had communicated with Currituck and that they were all in agreement
Okay.
with the information.
Okay. Okay. All right. Let's see, Mr. Franklin, we've got one for you. Hang on one second. Get organized here. Question for you, Mr. Franklin, about cost estimates on the types of the collection system alternatives that have been discussed in this case. In your direct testimony, you indicate that the exact costs for each of the sewer collection system alternatives wasn't known at that point in time. Is that still the case?
Yes.
Okay.
I think you heard from Mr. Meyer's testimony that he just recently got a new estimate for a low pressure system. So that's still the case. Yes.
Okay. Mr. Franklin, you were in the hearing room when Mr. Myers gave us his understanding of the timing of this transaction. Just to make sure we're all on the same page, can you help me understand the public staff's understanding of the timing of this transaction and specifically what has to happen in order for there to be closing and in order for there to be a transfer of the permit? Just walk me through the order of events.
I'll do my best.
Okay.
This is my understanding. Currituck will post the bond amount of $650,000 and
And
file that with the commission.
Are you, first, before you begin, are you assuming approval of?
Yes.
Okay, assuming approval of
Right.
this application?
That's right.
Okay.
Correct. And yes. That Currituck will post the bond amount of $650,000 and subject to commission acceptance. That Sandler is not authorized transfer of any of the assets of the utility, including the permit, unless until Sandler moves to join Currituck to the second amended consent judgment as defended. And
I'm sorry to interrupt, but that's been done by the second amended consent judgment, hasn't it?
Okay, all right. Um, let's see. And then once that is done, let's see. That the Superior Court will have to make a decision on whether they accept the second amended consent judgment and make any additional changes that they think are necessary. And at that time, my understanding is they can pursue with the closing and transfer of the system to Currituck.
Okay, so Mr. Myers testified today that assuming approval of the application, Currituck would be in a position to post the bond, the $650 bond or letter of credit that's been $650,000 bond or letter of credit that's been agreed to in the stipulation by mid-July of this year. I know the commission has on file a bond in the amount of, I believe it's $200,000 for Sandler.
That's right.
So at what point would we release this? What do you envision in the timing of this whole thing, releasing the bond that the commission holds for Sandler?
Once we have validation that the closing has occurred.
Okay, and so you anticipate closing won't occur until subsequent to entry of the execution of the second amended consent order?
That's right. That's my understanding, but
Okay. And you heard Mr. Myers' testimony about the transfer of the two permits at issue here, and
Right.
do you take any issue with his testimony to us today?
no.
Okay. Okay, all right, any additional questions for Mr. Franklin? All right, one last question for you all. This is in light of this, all of the facts and the circumstances underlying the evidence provided to the commission in this case, is it the public staff's opinion that transfer of this franchise and this wastewater utility system to Currituck is in the public interest?
Yes, with the oversight that's provided in the settlement agreement.
Okay, so so just to make sure I understand your testimony, assuming that Currituck complies with the terms and conditions of the settlement agreement and public staff is kept informed about what is transpiring at the system, as well as the relevant regulatory authorities or divisions within DEQ, public staff's position is this transfer is in the public interest.
That's correct.
And public staff feels comfortable that there are sufficient public customer protections in place with respect to the settlement agreement.
That's correct.
Okay, let me ask that clearer. The settlement agreement adequately protects consumer interests, those customers of this system.
That's correct.
Okay. Do you, has the public, there has, let me back up. Mr. Myers testified about the extensive outreach that's occurred with customers of the system over the past year. The commission held a public hearing in this proceeding. I'm satisfied the public staff has been interacting with customers of this system for some time now. Do you believe that this the commission's approval of this application is going to be well received by the customers of the system?
I think there are the concerns, I think, with some of the residents are the disruptions that would occur as a result of the collection systems replaced. and the impacts of those on their everyday life, like loss of power, like loss of internet connections, that sort of thing. But I believe with all the options that have been considered and all the that this is the best solution to the problems at Eagle Creek.
Okay. And when you say this is the best, you mean the
transfer.
transfer as envisioned by the settlement agreement?
That's correct.
Okay. All right, let me see if there are any other questions for Mr. Franklin. All right, let me check in with council. Questions on commission's questions?
No questions.
All right, Mr. Drews.
Sorry. So when that force main was installed, there were some interruptions that impacted customers. Is that right?
That's correct.
And did it turn out that those were not caused by Envirolink or Currituck, but instead by mistakes by the locator service of outside companies?
That's my understanding.
Okay. I'm not sure if this is necessary, but just want to ask if the bus staff would be amenable to, with the other parties to the settlement, filing a list of the activities, a timeline, a sequence, so that we can all be on the same page as to if this transfer is approved, what occurs next. Would y'all be willing to talk with us and then perhaps offer that as a late filed exhibit to the commission?
Yes.
Okay, thank you.
I'll take you up on that offer, Mr. Drews. We'll take a late filed exhibit setting forth the steps to closure and then permit transfer, et cetera.
We will do that.
Okay.
And last questions for Ms. Morgan. In your summary, you mentioned Currituck Water and Sewer file rebuttal testimony. Then you talk about you received updated information from the company that fed into your rate base and purchase price numbers. Was it Sandler Utilities that provided updated information on rate base and purchase price for your use?
I believe so.
Okay, thank you.
Yes.
That's all.
We've got one more question from Commissioner.
Yeah, I couldn't get your attention. I apologize.
Sorry.
We're talking a lot about the replacement and various aspects. From an operation standpoint, could you just clarify if there's anything in this agreement that is setting a higher, and if so, a significantly higher standard of operation requirements on this facility moving forth from other similar facilities in North Carolina? So staffing requirements, number of hours. I'm unfamiliar exactly with the operator sort of classification of this, but I know there's a lot in this discussion today about staffing. Is it a basic, or will we be moving forward with a higher level of staffing required for this facility than maybe DEQ would require?
Well, all the other systems in the state are operated by municipal systems and not by public utilities. So, but what I will say is the second amended consent judgment provides criteria for Currituck to meet, and that ensures that a higher standard of operation is maintained. They've seen significant improvement in operations since December of 2021, when the amended consent judgment took effect, and we expect similar continued satisfactory operation with the second amended consent judgment.
And I appreciate that. Maybe I wasn't just clear, but from a cost standpoint, from a number of hours, somebody on site, will this facility be operated differently than a facility down the street that wouldn't have gone through this entire process?
Well, if it's a different type of system, the thing about the vacuum system is really you need somebody there 24 hours a day, because as Mr. Myers testified, if you start having a leak in one of the valve chambers or the valve pits, and it goes unnoticed, it just cascades and can take down the whole system if it's not promptly corrected. So you don't have hours to wait to get the leak addressed.
And is it in your interpretation that level of operation will, if there's a different technology moving forward, that level of operation could change with it, or will the existing agreement carry forth to a potential system that could require less operation?
Sure, I think if it was a different type of system, there's the potential that there's less operational oversight than the current system.
Okay, we're not locking ourselves
No.
into the agreement. Okay,
No.
thanks.
I have a follow-up
Just
question.
one more question, and then I'll let you guys follow up. Mr. Franklin, did you review Mr. Meyer's testimony filed yesterday on the settlement agreement?
Not in depth, no, I just got this morning.
Okay, well, my read of the testimony, and your counsel can object to my read, but my read of the testimony is that the system is, the operation of the system is stable at this point in time and has been for a few months. Is that, do you take any issue with that testimony?
I do not.
Is that your opinion, public staff's opinion?
That's my understanding, and actually I had an email Sunday from the vice president of the HOA, and he stated the same thing, that the system's been stable since December of 2021. And also the engineer that Mr. Myers had mentioned that lives in the neighborhood. I checked with her when I thought the hearing was going to be earlier than this date. And she had told, so that was about a month ago, and she also told me that the system has been performing well since December of 2021.
So, is it your impression then that both of those individuals to whom you spoke are satisfied with the level of service being provided at this point in time in this, in the neighborhood?
Yes.
Okay. Okay, questions on commissioners, questions? Let's see, let's start over here. Okay, go ahead, public staff.
Mr. Franklin, responding to Mr. Hughes' questions, you said that the system, this vacuum system, needs an operator present 24/7. Is that a function of this type of system? Would another system such as a gravity feed system require a 24/7 operator?
I don't believe so, no.
And the other requirements, staffing and corrective actions, that's a lot of that is a function of the second amended consent judgment, or the amended consent judgment and the second amended consent judgment when that is entered with the Superior Court. Is that correct?
That's correct.
If the system is upgraded or the design changed to a gravity or a low pressure system, staffing requirements and maintenance requirements are going to be different. Is that correct?
That's correct.
So what we have today for maintenance and staffing is not set in stone then?
That's subject to change, yes.
No, that's all I have.
All right, if there are no additional questions, you all may step down and be excused. Thank you very much for your participation. I'll entertain motions from you, Mr. Little.
Move that the testimony and exhibits of Ms. Morgan and Mr. Franklin be admitted, and then the March 11th public staff response to Sandler, and the March 14th response to Currituck. Be moved into the record, and the other witnesses, public staff witnesses, Fought Tron, his testimony be admitted to the record.
Okay. All right. So hearing no objection to those motions, the exhibits attached to the testimonies of public staff witness Franklin and public staff witness Morgan are admitted into evidence. The public staff's responses to reports, one of which was filed on March 11th and the other of which was filed on March 13th, are admitted into evidence. The testimony, the joint testimony of public staff witnesses May and Tankard will be copied into the record as if delivered orally from the stand, and exhibits to that testimony will be marked for identification as they were when pre-filed and admitted into evidence, as will be the case with the appendices to that joint testimony. In addition, the testimony of Public Staff Witness Tron will be copied into the record as if delivered orally from the stand. Portions of his testimony are confidential and will be so identified in the record, and I ask the Public Staff Council to work with the court reporter to ensure that confidentiality is identified in the confidential information is clearly identified in the record. All right. With that, we will take proposed orders from the parties, 30 days from the notice of the filing of the availability of the transcript. Certainly we'll take them sooner if y'all want to get that done. Anything else before we adjourn for the morning?
Nothing.
All right, with that, we will be adjourned, and let's go off the record. Thank you very much, everybody.